And welcome to the Fearless Floyd Show. As always, it's this dude. It's that guy again. Yeah, well, all I got is the truth. That's all I'm searching for. Okay. Screw the BS, all that bull crap on the ground, all the drama, all of that. I've probably made at least 24 videos about Anna von Reitz and the whole scam of American state nationals and the de jure assemblies that are going to take over the de facto. I've done it's probably my dozenth, 12th one on just the bank alone. Now, I want you to utilize the comments today, because if you deposited money in Anna's bank, leave a comment below. If you have physically been inside of this global family bank, the actual physical bank, please leave a comment below and tell us all about it. Because as far as I know, I'm the only person in the world who's actually been in Global Family Bank at 2525 North Loop West Suite 125. And I've never deposited a penny in that account. I'm not associated with that at all. I went there to do an undercover video. And I did it. I did an 18-minute undercover video. About 14 minutes of it, maybe 13, 14 minutes of it is me having a conversation with the Global Family Bank CFO, the Chief Financial Officer, Arturo Coronel. It's on their website. Well, it was until I did my video. So I've been warning you folks, and warning you folks. Okay. Over and over and over till I feel like, I'm making videos about the same thing I made a video about a year ago, which is a bad thing to do when you're trying to be a person on social media with a presence, with some type of influence. But nobody wants to listen. Nobody wants to share these videos. Nobody wants to accept personal responsibility, accountability for their own actions, whether they're good, bad, or indifferent. And when you do that, it permeates. It's like throwing a rock in a calm lake, and all those ripples go all the way clear to the other side of the lake, even though you cannot even see the other side of the bank. And that's what it does when you continue this fallacy and you continue to follow these people, share the information, and don't hold yourself accountable. And when you see that, hey, maybe I was in with the wrong people doing the wrong thing at the wrong time in the wrong place, blah, 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 blah. Maybe I should tell other people not to do what I did, because that's what I do. That's why I told you I've abandoned all these processes, because they don't work. Even when they guarantee you it works, your money back, they don't work. And you can't get your money back. Those people disappear. It's really crazy. Or they're still out there scamming because people don't want to listen. And, I've exposed people, we're in the multi-millions now, folks. Okay. This isn't no chump change. When you start adding up all the victims and how much they've been taken for, we're in the millions of all the scammers that I've covered. The Patricia and her little bullshit. And we got Anna Con Reitz doing her little bullshit. Todd Noel doing his little bullshit. I can go down this list. Apparently now Chris Hauser has moved on to something else, and he's charging, I heard, some stupid amount of money. And it's ridiculous. Okay. And I'm tired of making these videos. I'm tired of covering this stuff, because when you going to wake up? How stupid can you be to literally send your entire life savings, everything that you've worked for 20, 30, 40, 50, 60 years for some people, just to give it all away to some unknown entity, to a entity that you've never physically even been in. You don't even know where it's going. Your money could be going to some Asian gangster, could be going to some bank account in Switzerland, or to a Citibank in Georgia. Well, I thought that was the whole purpose of the global family bank, is to be outside the traditional financial economy. God bless them. For the ignorant shall perish for a lack of knowledge. Okay, let me show you what's going on. Okay, this isn't me. This is from a magistrate judge in the Northern District of Georgia, United States Court, issuing her recommendation to the district judge for further proceedings. So I'm going to play this for you. I did the talk to text thing. It's all automated, so it's not me. Let's see if I can play it for you. That's the problem. I'm trying to figure out how to play a MP3 when StreamYard only accepts MP4s. So I'd have to redo it. So let me see if you guys can hear this.
United States versus Global FG Enterprises, LLC.
Let me see if you guys heard that. Somebody leave me a comment and tell me if you heard that. So I want to play it for you. I don't want to have to read it. I can show it to you. Where's it at? Yep, here it is. United States versus Global FG Enterprises, LLC. You're saying that right? Let me remove my happy ass out the way because you ain't here to see me. I know that. Let me give you a black background as well. Nobody's left me a comment telling me, yes, you heard it. Okay, good. I'll scroll along.
United States versus Global FG Enterprises, LLC. 1:25. Me, 00057 *. Northern District of Georgia. September 18th, 2025. Check treatment. Docket. Order and final report and recommendation. I. Background. 2. Discussion. A. The response and notices of filing are improper and will be stricken. B. Respondent should be held in contempt. 1. Legal standard. 2. Certification of facts. 3. Conclusion. Notes. Order and final report and recommendation. The above styled matter is before the court on the court September 4th, 2025. Order, Document 7, on Respondent's response to order to show cause, Document 8, and on Respondent's various notices of filing docs, 9 to 12. For the reasons below, I will order that Respondent's response to order to show cause and the notices of filing be stricken.
Now, for those of you out there who don't understand or comprehend the titles of the parties to this action, the United States is the plaintiff and Global FG Enterprises is the defendants, okay? Because there's a bunch of them. It should say et al., but it doesn't. So when they talk about respondents, that's the court directing the parties to respond. So that's what we're talking about.
And I will recommend that respondent be held in contempt for its refusal to comply with a subpoena. I. Background. This miscellaneous matter pertains to an underlying action in United States District Court for the District of Alaska, United States versus Anna M. Riesinger von Reitz, number 3:23, CV 260, JMK, underlying action. On June 5, 2024, the United States obtained a money judgment in the underlying action against Anna M. Riesinger von Reitz, aka Anna Marie Riesinger, aka Anna M. Belcher, Riesinger. The United States is currently engaged in post-judgment discovery to attempt to recover or execute the judgment in the underlying action. Document 1-1, Deckel. Of Daniel A. Applegate, Deckel, paragraph 2. During its post-judgment discovery efforts, the United States learned that Riesinger purchased a half-interest in certain real property from her sister's estate in October 2024. Using a check issued from a Citibank account in the name of Respondent Global FG Enterprises, LLC, Respondent. ID paragraph 2. On March 24, 2025, the court in the underlying action issued a subpoena duces tecum to Respondent. Applegate Deckel, paragraph 3, document 1-2 at 1-7. Point 1, the subpoena.
Okay, to clarify for you folks, keep you up to date on who's who. Daniel A. Applegate was the Department of Justice attorney for the IRS who sued Anna von Reitz and won by default judgment because, guess what Anna did? She didn't appear before the court. She disappeared. She never showed up, so they got a default judgment. So guess what's getting ready to happen here? Oh, no. Yeah, so that's who Daniel A. Applegate is, and that's why they're talking about his declaration. But really, it's kind of crazy that Anna would use money from Global Family Bank to purchase real property from her sister? Do you think that's a red flag? Do you think that's suspect? I don't know. I'm just here searching for the truth. What is the truth?
Ina commanded Respondent to produce certain documents on April 23, 2025, at 10 a.m. at the United States Attorney's Office in Atlanta, Georgia. Applegate Deckel. Paragraph 4. Document 1-2 at 1. The United States served Respondent with the subpoena. Applegate Deckel. Paragraphs 5-7. Document 1-5. Document 1-6. Document 1-7. Document 1-8. Hunter Toyo Fukuaki, who is Respondent's sole member and registered agent, sent letters to counsel for the United States relating to the subpoena. Applegate Deckel. Paragraphs 4-5, 8, 10. Document 1-3. Document 1-4. Document 1-10. Document 1-12. Respondent, however, produced no documents in response to the subpoena. Applegate Deckel. Paragraphs 8, 10, 12-13. Document 1-10. Document 1-12. On August 5, 2025, the United States filed its motion for order to show cause, requesting that the court issue an order directing Respondent to show cause why it should not be held in contempt for its failure to comply with the subpoena. Document 1. On August 13, 2025, I ordered counsel for the United States to serve a copy of the motion for order to show cause on Respondent and to file proof of service with the court within 2 days after service. Document 3 at 2-3. I ordered Respondent to file a response to the United States' motion for order to show cause within 14 days after being served with the motion to show cause and related documents. ID at 3. The United States filed a return of service reflecting that it served Respondent with a copy of the motion to show cause and related documents, as well as the court's August 13th order on August 15, 2025. Document 4. The United States later filed a second return of service reflecting that it served Toyo Fukuoka with the same documents on August 19, 2025. Document 5. On September 2, 2025, the clerk received a document purportedly filed by Riesinger and signed by Toyo Fukuoka on Riesinger's behalf titled, International Public Notice. An End to an Unlawful Court System. Document 6-1-4. That filing did not provide a substantive response to the government's motion for order to show cause. See generally, ID. Instead, the filing argued that the United States District Courts are unlawful equity courts. See generally, ID. On September 4, 2025, I granted the government's motion for order to show cause. Document 7. I ordered respondent to show cause within 10 days why it should not be held in contempt. ID at 8. I stated, if respondent fails to comply with this order or if its response is insufficient, I will certify facts showing that a finding of contempt is warranted and present those facts to the district judge via a report and recommendation. ID. I also cautioned respondent that, as a limited liability company, it could appear in this action only through an attorney and could not be represented by a corporate officer or member. ID at 8-9. Respondent did not file a substantive response to the September 4, 2025, order. See generally, docket. Instead, on September 15, 2025, respondent filed a response that contained a request for a stay. Document 8-1. The response states, in relevant part, I do hereby and herein request a stay in said instant matter since no information of the requested items to cause were provided to Toyo Fukuoka, and we are now filing a notice of claim against Daniel A. Applegate as trial attorney for the Department of Justice for making false and misleading statements causing injury and damages against Toyo Fukuoka. This undertaking as above referenced will be taken in this very same court and will be required to be sitting as an article the third court. Should this court not issue a temporary stay, we will immediately file our action in the U.S. Court of Appeals and name also this court and the judge of record in addition to other parties involved in the illegal taking from Toyo Fukuoka. ID. The response was filed by Richard E. Warren on behalf of Toyo Fukuoka. ID. Warren signed the response. Richard E. Warren Assistance of Counsel by contract. ID. The envelope containing the filing lists a return address of First-Rate Legal Consulting Care of 151. Whitewood Road, Unit 2, Charlottesville, Virgin, I at 22901. ID at 2. On September 16, 2025, the clerk received 4 documents from respondent. Docs 9-12. The first document is titled Cover Letter, Notice to Recipients, and it states in relevant part, each of you are required by law to respond within 14 days from receipt hereof. Day received excluded. This matter concerns a counterclaim against the parties named in the enclosed documents as and for injury and damages in the sum certain amount as specified in such documents. This is a serious matter, and we are prepared to this matter as far as we must in which ensure justice and recoupment of the funds taken without authority. Each of you are required to respond to us by and through our assistant of counsel with whom we have a contract with to assist us, and to the court in a notice of response to the judge assigned in the instant matter. Please be advised that your failure to respond within the time frame allotted to herein are subject to the judge being forced by law to rule against you. Document 9. Warren signed the document on respondent's behalf. ID. The second document is titled Declaration of Global FG Enterprises, LLC, Hunter Toyo Fukuoka Registered Agent.
Okay, the reason that you see these brackets around letters right here is because apparently it was misspelled. And when they court transcribed these, they put the brackets around them. Like right here. I don't know whether it misread it or whatever in the scan. I don't know. But anyway, that's the deal with that. So here we are right here. We'll carry on.
Document 10 at 3. It is signed by Toyo Fukuoka, apparently on respondent's behalf, and, instead of making factual allegations, contains a list of purported legal claims. ID at 3 to 5. The third document, titled Declaration of Lin Toyo Fukuoka, also contains no factual allegations. Document 11 at 3. Instead, the document contains a list of purported legal claims. ID at 3 to 5. Lin Toyo Fukuoka signed the document, apparently on respondent's behalf. ID at 4. The fourth document is titled Declaration of Joshua Bryce Pelletier. Document 12 at 3.2. That document, like the other purported declarations, contains no factual allegations and sets forth a laundry list of alleged legal claims. ID at 3 to 4. Joshua Bryce Pelletier signed the document on respondent's behalf. ID at 5. 2. Discussion. A. The response and notices of filing are improper and will be stricken. Respondent has been cautioned that it may appear in this action only through an attorney. Document 3 at 3. Document 7 at 8 to 9. It appears that Warren, who submitted respondent's response to order to show cause and its first notice of filing, is not admitted to the bar of this court or the State Bar of Georgia. The local rules prohibit individuals who are not members of the bar of this court from appearing in cases before the court, and non-admitted individuals who do so may be subject to discipline. CLR 83.1 F 14 NDGA. Any person not admitted to the bar of this court, or any attorney disbarred or suspended by this court, who exercises any of the privileges bestowed upon members of this court's bar, or pretends to be entitled to such privileges, will be adjudged guilty of contempt and may be subject to other discipline by the court. And Georgia law provides that it shall be unlawful for any person other than a duly licensed attorney at law to, among other things, practice or appear as an attorney at law for any person other than himself in any court of this state or before any judicial body. Render or furnish legal services or advice, or render legal services of any kind in actions or proceedings of any nature. OCGA Section 15-19-51, Warren, as a non-attorney, thus may not represent respondent or file documents on respondent's behalf. Because Warren is not authorized to act as counsel for respondent or file documents on respondent's behalf, the response and the first notice of filing were improperly filed. I will direct that these documents be stricken. The other 3 notices of filing, which purport to be declarations, are not actually declarations. Docs 10 to 12. Rather, these documents contain lists of legal claims. The documents were also filed by non-attorneys on respondent's behalf. Respondent has been notified twice that it must retain counsel to represent it, and that its members or officers may not attempt to appear on its behalf in this case. These notices of filing are improper, and I will direct that they be stricken. Point 3. B. Respondent should be held in contempt. 1. Legal standard. Federal Rule of Civil Procedure 45, D. 2. B. I. Provides that the federal court where compliance with a subpoena is required has jurisdiction to compel a party served with a subpoena to comply with the subpoena. Fed. R CIV P 45D 2 B I. Rule 45G also provides that he court for the district where compliance is required may hold in contempt a person who, having been served, fails without adequate excuse to obey the subpoena or an order related to it. Fed. R CIV P 45G. A subpoena issued on behalf of the court should be treated as a court order. C-Fed. R CIVP 45A Advisory Committee Note to 1991 Amendment. Although the subpoena is in a sense the command of the attorney who completes the form, defiance of a subpoena is nevertheless an act in defiance of a court order and exposes the defiant witness to contempt sanctions. See also Res Investments Incorporated v. United States. 97 Federal CL 545, 552, Federal CL 2011. Failure to obey an attorney-issued subpoena is an act in defiance of a court order and exposes the defiant witness to contempt sanctions under Rule 45E. Quotation marks and citation omitted. Civil contempt is a process used by a court to compel compliance with a subpoena or court order. United States v. Vito, number 1:22, Me, 34, WMR, JM, 2022, WL238, 9265, at *2, Endiga, June 3, 2022. Quoting Gladden v. Procter and Gamble Distrib. LLC, number 1:19, CV, 2938. CAP, JSA, 2020 WL10145958, at *4, Endiga, July 20th, 2020. Adopted by 2022 WL336440, Endiga, July 1st, 2022. C. Civil contempt occurs when a party disobeys a specific and definite court order by failing to take all reasonable steps within that party's power to comply with the order. ID, quoting Gladden, 2020 WL1045958, at *4. Even if the party is in contempt, the decision to impose sanctions for that conduct is discretionary. ID. A finding of civil contempt must be supported by clear and convincing evidence. Rickard v. Prudential Insurance Company, 307F.3D 1277, 1296, 11th Circle 2012. The party seeking civil contempt sanctions must show by clear and convincing evidence that 1. The allegedly violated order was valid and lawful. 2. The order was clear and unambiguous. And 3. The alleged violator had the ability to comply with the order. ID. Once this prima facie showing is made, the burden then shifts to the alleged contemner to produce evidence explaining his non-compliance at a show cause hearing. Chairs v. Burgess, 143F.3D 1432, 1436, 11th Circle 1998. Quoting Citronelle Mobile Gathering Incorporated v. Watkins, 943F.2, D 1297, 1301, 11th Circle 1991. Under the Federal Magistrates Act, United States magistrate judges have limited power to exercise contempt authority. Perez v. Guard Serves. International, Inc., number 1:16 Me, 36. CAP, JSA, 2016 WL115847883, at *2, Endiga, December 22, 2016, adopted subnom. Hugler v. Guard Serves. International Incorporated, 2017 WL110488839, Endiga, March 22, 2017. A magistrate judge's power to exercise contempt authority in a civil case is limited to those situations when both parties consent to having the magistrate judge preside over the case. ID Smith v. Pefonis, 652 F. Sup. 2D 1308, 1315-16. Endiga 2009. If both parties have not consented to having a magistrate judge preside, the magistrate judge's role is limited to certifying the facts underlying his or her belief that contempt is warranted and presenting that report and recommendation to the district judge. Perez, 2016 WL 11584783, at *3. The district judge, in turn, shall thereupon hear the evidence as to the act or conduct complained of and, if it is such as to warrant punishment, punish such person in the same manner and to the same extent as for a contempt committed before a district judge. 28 U.S.A. Section 636, E. 6, B. See also Perez, 2016 WL 11584783, at *3. When a magistrate judge has certified facts supporting a finding of contempt, the district judge is then required to conduct a de novo hearing at which issues of fact and credibility determinations are to be made. 2. Certification of facts. I certify the following facts that support a finding of contempt to the district judge. The district judge may then conduct a de novo hearing. 28 U.S.C. Section 636, E. 6, B. Perez, 2016 WL 11584783, at *3. On June 5, 2024, the United States obtained a money judgment in the underlying action against Reisinger, and the United States is currently engaged in post-judgment discovery to attempt to recover or execute the judgment in the underlying action. Applegate Deckel. Paragraph 2. During its post-judgment discovery efforts, the United States learned that Reisinger purchased a half-interest in certain real property from her sister's estate in October 2024, using a check issued from a Citibank account in respondent's name. ID Paragraph 2. On March 24, 2025, the court in the underlying action issued a subpoena duces tecum to respondent. Applegate Deckel. Paragraph 3. Document 1-2 at 1-7. The subpoena commanded respondent to produce certain documents on April 23, 2025, at 10 a.m. at the United States Attorney's Office in Atlanta, Georgia. Applegate Deckel. Paragraph 4. Document 1-2 at 1. The United States served respondent with the subpoena twice. Applegate Deckel. Paragraphs 5-7. Document 1-5. Document 1-6. Document 1-7. Document 1-8. Respondent refused to comply with the subpoena. Applegate Deckel. Paragraphs 3-8, 10, 12-13. Document 1-2 at 1-7. Document 1-5. Document 1-6. Document 1-7. Document 1-8. Document 1-10. Document 1-12. On August 5, 2025, respondent filed a motion for order to show cause, requesting that the court issue an order directing respondent to show cause why it should not be held in contempt for its failure to comply with the subpoena. Document 1. On August 13, 2025, I ordered counsel for the United States to serve a copy of the motion for order to show cause on respondent and to file proof of service with the court within 2 days after service. Document 3 at 2-3. I ordered respondent to file a response to the United States' motion for order to show cause within 14 days after being served with the motion to show cause and related documents. ID at 3. The United States filed a return of service reflecting that it served respondent with a copy of the motion to show cause and related documents, as well as the court's August 13th order on August 15th, 2025. Document 4. The United States later filed a second return of service reflecting that it served Toyo Fukuoka with the same documents on August 19th, 2025. Document 5. Respondent did not file a substantive response to the motion for order to show cause as directed in the August 13th, 2025 order. See generally, docket. Instead, Toyo Fukuoka filed a document, purportedly on Riesinger's behalf, that raised only sovereign citizen type arguments. Document 6. I found that the document was improperly filed and did not refute the government's motion. Document 7 at 6 to 7. On September 4th, 2025, I issued an order to show cause directing respondent to show cause in writing within 10 days why it should not be held in contempt. Document 7 at 8. The clerk was directed to mail the September 4th, 2025, order to respondent at 3 different mailing addresses, including 1. Global FG Enterprises LLC, care of Hunter Toyo Fukuoka, registered agent, 3780, Old Norcross Road, Suite 103283, Duluth, Georgia, 30096. 2. Global FG Enterprises LLC, care of Hunter Toyo Fukuoka, registered agent, 2525, North Loop West Suite 125, Houston, Texas, 77008.
Told you I've been there. Y'all thought I was kidding? That's right down the street. When I was in the Texas State Assembly, and I was asked to find a physical bank, I actually found one about a mile from this location on the same freeway along the feeder. Absolutely, I did. So let's continue. For those of you who have not been to this address, if you're in Houston or the surrounding area and you'd like to visit the bank, as the court has found, there you go. There's your address. It's on the first floor.
And 3. Global FG Enterprises, LLC, care of Hunter Toyo Fukuoka, registered agent, 1738, Wren Avenue, Corona, California, 92879. Document 7 at 8. Respondent did not show cause in writing as directed. See generally, docket. Instead, Warren, a non-attorney, filed a response on respondent's behalf that requested a stay of proceedings. Document 8. That response was improperly filed and has been stricken. Warren also filed a document titled Cover Letter, Notice TO Recipients on respondent's behalf. Document 9. That document was improperly filed and has been stricken. Toyo Fukuoka, Lynn Toyo Fukuoka, and Joshua Bryce Pelletier all filed documents on respondent's behalf that purported to be declarations, but instead contained a laundry list of alleged legal claims. Docs 10 to 12. These documents were improperly filed and have been stricken. I find, by clear and convincing evidence, that respondent has refused to comply with the subpoena in the underlying action and the court's September 4th, 2025, order. Respondent has made no effort to comply with the subpoena. It has made no effort to show cause as required by the September 4th, 2025, order, instead choosing to have a person who is not admitted to practice before this court file a baseless request for a stay that raises frivolous arguments, and choosing to file documents that are replete with frivolous, sovereign citizen type claims. See generally, Docs 8 to 12. Both the subpoena and the September 4th, 2025, order were valid, lawful, and properly issued. The subpoena was clear and unambiguous. And so was the September 4th, 2025, order. Finally, respondent had the ability to comply with both the subpoena and the September 4th, 2025, order but refused to do so. I, therefore, recommend that respondent be held in contempt for failure to comply with the subpoena and with the September 4th, 2025, court order. I also recommend that respondent be sanctioned for its contempt, including 1. Being required to pay reasonable costs and attorney's fees associated with the government's motion to show cause, and 2. Imposing a reasonable daily monetary fine until respondent fully complies with the subpoena, or, if the court finds it appropriate, ordering that a member of respondent be incarcerated until respondent fully complies with the subpoena. 3. Conclusion.
Before we get there, they recommended to the district judge that the district judge almost like 90% of the time will just sign it, rubber stamp it, whatever the magistrate asks for. So guess who's going to pay these reasonable costs and attorney fees associated with the government's motion and a daily monetary fine? Yeah, you are. Your money. Let's move on to 3, the conclusion.
Accordingly, IT is ordered that respondent's response to the order to show cause, document 8, is stricken. I recommend that respondent be held in contempt for its failure to respond to the subpoena in the underlying action and its failure to comply with the court's September 4th, 2025, order. The clerk is directed to send a copy of this order to respondent at the following mailing addresses. 1. Global FG Enterprises LLC, care of Hunter Toyo Fukuwaki, registered agent, 3780, Old Norcross Road, Suite 103283, Duluth, Georgia, 30096. 2. Global FG Enterprises LLC, care of Hunter Toyo Fukuwaki, registered agent, 2525, North Loop West Suite 125, Houston, Texas, 77008. And 3. Global FG Enterprises, LLC, care of Hunter Toyo Fukuwaki, registered agent, 1738, Wren Avenue, Corona, California, 92879. Because this is a final report and recommendation, and there is nothing more pending before the undersigned, I direct that the clerk terminate the reference of this case to me. So ordered and reported and recommended. This 18th day of September, 2025. Catherine M. Salinas, United States Magistrate Judge. Notes. 1. Citations are to CM/ECF numbering. 2. Pelletier's relationship to respondent or the Toyo Fukuwakis is unclear. 3. Even if the court considered the declarations, these documents do not show cause for respondent's failure to comply with the subpoena or demonstrate compliance with the September 4th, 2025, order directing respondent to show cause why it should not be held in contempt.
Now, here's like a handful of cards. You do see that address, right? If I had a microphone, I'd drop it. So there you go. I'm going to follow this case and see what else is going on. And, uh, who the hell's really running the show over there? And these people, they can't even hire a real attorney to represent them because they're so incompetent, legally incompetent. They're legal morons. I don't understand why you people continue to listen to this charade, this fallacy of somebody that is just so incompetent, just as a human being, okay, who can't manage their own affairs. And you're going to like give her all your money to manage as the fiduciary? Have you lost your frickin' mind? I think you should go consult a life coach and a wealth manager and run that by them and see what they have to tell you. So thank you for watching. I appreciate it. I didn't run the banner. If you need something on trusts, I've got books, classes, consultations, everything you need. FearlessFloydShow@yahoo.com. If you want to reach me, or I'm sorry, thefearlessfloydshow.com. If you want to reach me, it's thefearlessfloydshow@yahoo.com. All you got to do is go to my website. I think down at the bottom is my phone number. So you want to call me and talk to me, you're more than welcome to do that. I did reach out to a constitutional sheriff in the Federation of States, Ohio State Assembly. Spoke to him yesterday for an hour at least, and had a great conversation. So, listen, folks, we're not that far off at all. Just not. But because of these barriers of leadership and authoritarianism and egotism and narcissism that divide and conquer, keeps everybody separated when we should all just like oversee these little nuances of our differences and see the forest. Okay, not see the trees, see the forest, and come together and work together to change our community back to our way of life, to how it should be. Because if you expect it to change organically as is, it's not going to happen. If you expect it to change over in this inorganic entity, it's not, okay? Because the organic's not going to allow that to happen ever. No, they're not going to surrender their power. That's just the way the world works. Okay. Once you attain that power, very rarely do you ever relinquish it. That's part of the why we're never going to see anything about the Epstein files. That's why they keep throwing this UFO stuff at you about every, 45 days. There's a new batch. That'll keep them interested. Yeah, y'all look over here, look over here, look over here. Y'all forgot all about the Epstein files, didn't you? That we're all pedophiles, satanic, adrenochrome junkies. No, we didn't forget. So there you go. Go by the bank. Call Arturo here. You can call him at 832-618-1600. I hope his phone's ringing off the wall. If you want to email him, it is ac@coronelfinancial.com. coronelfinancial.com's website. Just Google the address, 2525 North Loop West, Houston, Texas, 77008. You can see what's in that building. You can actually see the building. So thank you everybody for watching. Appreciate you being here. I'll catch you on the next one. Y'all know what to do.